Good afternoon and welcome to the Juvenile Justice Oversight Council. I hereby call the council to order. Mr. Clerk, please call the roll.
Mr. Adams, Ms. Gardner,
Derek Selznick for Ms. Garner.
Mr. Gold,
Here.
Mr. Ramsey,
Jason Reynolds here for Director Ramsey.
Ms. Walker, Mr. Ward, Ms. Dennis,
Here.
Mr. Fletcher,
Christina Weeder here for Commissioner Fletcher.
Mr. Jackson, Ms. Marks,
Randy
Beth
White
Jordan
here
for
for
Commissioner Marks.
Secretary Jackson.
Mr. Preston, Mr. White,
Here, going back, Randy White here for Secretary Jackson also.
Senator Carroll,
Here for Senator Carroll.
Senator Herron, Representative Wilner,
Here.
Representative Wilson,
Here.
Co-Chair Storm,
Here.
Co-Chair Elliott.
I'm here, so we do have a quorum and we're duly constituted to conduct business. Is there a motion to approve the minutes of October the 8th, 2025?
Motion.
There's a motion. Is there a second?
Second.
There's a second. All those in favor, please say aye. Aye. Those opposed, no, and the minutes are approved. I'll recognize my colleague, Senator Storm, the co-chair, for introduction of guest.
Thank you, Mr. Co-Chair. I'd like to introduce my good friend and constituent Terry Martin with Martin's Peterbilt in the back of the room. Thank you for being here.
Welcome. Thank you. Thank you for being here on a Friday. So thank you. So today we're going to have as any other member seek recognition. Senator Carroll.
Thank you, Mr. Chairman. And I just happened to look down and read the name and look up, and there he is. The county attorney from my home county of Marshall, Jason Darnell, is here, good friend, a great guy, and Marshall County is fortunate to have him. He does an awesome job in that county and very well respected, and I'm glad to have him here today and look forward to his testimony.
Welcome, and thank you for being here. I know you've come a long way, so we thank you.
Exactly.
Thank you. Oh, wow. Well, thank you for being here, and I know you're going to be part of our discussion on juvenile interrogation. Does any agency have an update that they would like to share? And the AOC has filed a report as usual, which is in our packet. So if not, I'll move to our topic of discussion today, and that's juvenile interrogation. And we have several presenters who are listed on the agenda to talk to us today. If you would come forward. Okay, and I know Miss Downs with Kentucky Youth Advocates has a PowerPoint, so why don't we start with that? So we'll ask Kentucky Youth Advocates to come forward, and Dr. Moody's here. If you would introduce yourselves, and then you can proceed with your presentation.
All right. I am Courtney Downs with Kentucky Youth Advocates.
Shannon Moody with Kentucky Youth Advocates. I'm grateful for your all's time today.
All right. So at Kentucky Youth Advocates, we are a nonpartisan. Oh, wait a minute. Let me go to presenter view. Sorry. Hold on. There we go. All right, so at Kentucky Youth Advocates, we are a nonpartisan policy advocacy organization whose vision is to make Kentucky the best place in America to be young. And for those who are unfamiliar with KYA, we do take a whole child approach to our work, centering the needs of children and families in the arenas of child welfare, juvenile justice, education, economics, and health. We advocate for policies, practices, and investments that will support kids and families. We engage people with lived experience in our work, and we also use data and research to inform our advocacy efforts. Another big piece of our work is that we are the backbone organization for the Blueprint for Kentucky's Children, which is a statewide coalition that comes together to speak with a common voice to create brighter futures for every Kentucky child and their families. And one of our priorities on our Blueprint for 2026 is requiring children to consult with an attorney prior to waiving their Miranda rights. As a caveat, I will say that I am not an attorney, so I'm glad that there are several attorneys here today who can speak to the practicalities of this. I will really just be focusing on what the research and the data shows about it. Okay, so what could early access to attorneys look like? So the things that we have been advocating for specifically is mandatory consultation with an attorney prior to waiving those rights. The legal consultation could occur in person, virtually, or over the phone, and we have been advocating for privacy and confidentiality to be ensured as well. When you look at the laws in other states around custodial interrogations, there is almost always a carve-out included when there is this imminent threat of harm against a person or property. And then also, since 2021, and I'll get into this a little bit more in a couple of slides, there have been several states that have also enacted laws that prohibit the use of certain deceptive tactics during interrogations. Those are usually standalone bills, which is why we haven't explicitly included it in any of our advocacy so far this session, or in the interim. So kind of getting into why kids need early access to attorneys. When you look at a child's brain, obviously, you know, like adolescent brains are going to work very differently than adults, especially when it comes to making decisions and solving problems. Their actions are largely guided by the more emotional and reactive parts of their brain and significantly less by the thoughtful and logical parts of their brain. Research has also showed that early access to drugs and alcohol use during their teen years especially can also change or delay a lot of these developments. So young people's ability to control their impulses, to regulate their emotions, and to make decisions are a critical part of brain development that's happening in their teens and in their 20s. So kids of this age are usually more susceptible to those immediate rewards, to peer influence and approval. They also may struggle to anticipate the consequences of their actions. They are more likely to get into accidents of all kinds, to be involved in different kinds of fights, and they are far less likely to change their dangerous, risky, or otherwise impulsive behaviors. Adolescents typically, what the research has shown is that the ones who have that better emotional regulation also tend to have stronger attachments, and they are much less likely to translate that impulsivity into higher risk behaviors. And we see pretty much the opposite with youth who are maybe not as connected to their parents, to their peers, or to their schools in general. And then if we put this, I guess, in the context of having early access to an attorney, kids are less likely to understand their legal rights or the legal process just in general, and they are more susceptible as well to false confessions. I do want to say before going on to the next piece of this that these brain differences don't mean that young people can't make good decisions or tell the difference between right and wrong. It also doesn't mean that they can't be held accountable or accept responsibility for their actions. It just means that if we are more aware of these factors, then we can kind of understand, we can anticipate and also help to manage some of their behaviors. So continuing on, kind of looking at the false confession piece. So data from the National Registry of Exonerations, and this is from 2022, there were 268 exonerations at the time that involved people who were under the age of 18 when the crime was committed. And so of that pool, 34% of them involved false confessions. So of the exonerations that were involving kids who were 16 and 17, 27% of them had falsely confessed. When you look at the cases involving kids who were 14 and 15 at the time, 54% of them had falsely confessed. And then when you look at the cases involving kids under the age of 14 at the time, 78% of them had falsely confessed. They also have data showing that of the 174 total defendants who were exonerated and also diagnosed as mentally ill or intellectually disabled, 69% of those were for false confessions. And about, if you hone in a little bit more, 34 of them were under the age of 18, and so 79% of that group had also falsely confessed. So moving on to what other states have done so far, and we see a lot of variance in the laws from state to state. In Maryland in 2022, they passed the Child Interrogation Protection Act, and this requires kids to have access to an attorney before questioning. It also established a 24-hour legal hotline, and as of right now, that hotline is actually being studied as a national standard. We also saw in 2024 where Indiana updated their statute to allow kids' attorneys to only allow a child's attorney or their parent, their guardian, or their guardian ad litem to be the ones to waive their constitutional rights under certain circumstances. The only way that a child can waive their rights on their own is if they are emancipated and they have voluntarily, knowingly and voluntarily consented to that. There is also, I think in more than 30 states, they now require all interrogations, whether it's juveniles or adults, to be recorded. There are some states that require an attorney or a parent to be present during the interrogation, and then there are other states that only require the child to be notified that they are allowed to have their parent or an attorney in the room with them. And then we have also seen several states that are starting to define the places of detention to include police stations, police vehicles, and schools as well. So essentially anywhere that questioning or an interrogation could take place. So to wrap this up, our recommendation is to make sure that kids are having that early access. We know that every year kids accept responsibility in court while being represented by attorneys who advise them of their rights and explain the legal process to them. So again, by requiring kids to speak with an attorney before waiving their Miranda rights, we can ensure that they have the support that they need to make an informed legal decision about their future. That is all I have.
Thank you very much. Dr. Moody, do you have any comments you'd like to add?
I'm here for moral support.
I understand. Ms. Walker, you're recognized.
Thank you. One of the questions that I have, well, one question is, do you all take trauma, like do you all obtain data with juveniles who have experienced traumatic and have had some type of traumatic experience in their lives?
Do we at Kentucky Youth Advocates, do we collect?
Yes, I heard you talk about the data, but is that some of the data that you collect?
So yeah, we would be able to get data related to like ACEs,
okay,
those adverse childhood experiences, and
okay,
we could definitely.
And that plays a factor into.
Yes.
Okay.
Yeah. Is that something that you want us to send to you? Is there okay?
Thank you. Does any other member have any comments or questions that they would like to address? Senator Carroll.
Just quickly, thank you, Mr. Chairman. And I understand what you all are saying, what you're getting at. Are you all advocating that anytime law enforcement interviews a child in relation to a crime, they would speak to an attorney?
I will say we probably have to have some conversations about like what the specifics will look like, but so far, what we have talked about is making sure that
and you understand that is just absolutely not feasible at all. And the delay in investigations and the time that it would take up for law enforcement to wait on minor issues before they talk to a juvenile, that is absolutely unreasonable to expect that.
Okay. Well, I would assume, I can't speak for the chairs, but I would assume that's part of why we're having the discussion now, so that we can also figure out if there are certain offenses. And I know in other states that's what they have done. They have said, only for these specific offenses, and usually it would be like the more violent offenses.
Yes.
And then there are also certain states that say by kids under a certain age, whether it's like 14 or 15, mandating that they have to have that consultation before.
Okay.
And so,
and is there a thought that it making it mandatory to speak to the parents rather than an attorney?
there are a lot of states that do that as well. So I think that could be a part of the conversation. But I think, having a legal expert be able to actually walk a child through like what the legal process looks like, and what they can expect and what their rights actually mean is probably most helpful.
And in a lot of, and Mr. Chairman, may I just quickly, in a lot of issues, if a kid speaks to an attorney, the kid's never going to be speaking to law enforcement. And it increased, and this is, I'm not saying I'm supporting anything, I'm saying this because I believe this is a possible reality, that the kids are going to get away with whatever they've done. They're not going to be held accountable, that will just lead to other acts. And the juvenile justice system is more set up today to provide treatment for juveniles, and that's kind of the approach that we're taking more these days. So what's best? The juvenile to be interviewed, admit, and let the courts address that, and then let the juvenile justice system treat that child and hopefully prevent any further actions in the future. If they get away with it once, they're going to do it again. So I guess that's a thought that came to my mind. What would be best for the child, to see an attorney, never speak, get away with it, or be held accountable for it and receive treatment and hopefully deter any future actions?
I think the attorneys can also speak to this, but I don't think that consulting with an attorney prior to an interrogation actually negates any part of the interrogation process.
Oh, sure it does, because the attorney's going to tell the kid not to talk. Always.
Well, and I'll just add, I think it's important to note that the Supreme Court has said in the Galt case in 1967 that young people who have alleged to have committed offense must receive notice of the charges, be informed of their right to counsel, as well as the right to cross. So the 14th Amendment does apply to juveniles, just as it does to adults. So I think that's probably when you're talking about attorneys need to speak up. Yeah. So the Constitution obviously does apply to a juvenile who is in custodial interrogation. Custodial interrogation is typically defined, one of your earlier questions, is when someone is not free to leave. So as you know. So I think there are a lot of ways to look at this, but one of the reasons that I wanted to have a discussion on this is that we do have situations where I think it's shown in your presentation that we have false confessions being extracted from juveniles who maybe, if they had had the opportunity to have had a parent or even a lawyer, that wouldn't have happened.
Yeah.
So, but I also understand
Mr. Chairman,
your question.
I don't disagree at all. But
and it would put, I think, just to flesh out what you're saying, is that it would put DPA on all of these cases very early, because they typically get all of them anyway. Yeah. So I think just to flesh out what, and
yeah, I guess I'm thinking more at the scene, because there are, even in smaller cities, there are dozens of incidents daily. Damon doesn't have the staff across the state to have a public defender there at every time a law enforcement in that type of situation. So,
and I figured he would have some comments today.
Probably several.
But not to take up your time.
Thank you, Mr. Chairman. I'm done. I appreciate the latitude.
Absolutely. Mr. Gold, I think you were seeking recognition.
Thank you, Mr. Chairman. And I know I've got some colleagues that will be speaking soon, and they will very ably do so. I just have a couple of questions, and they're kind of along the lines of where Senator Carroll was going. First and foremost, as was discussed, this has been this is something that could be dealt with legislatively, or it can be dealt with judicially. through courts, and we heard about the In re Galt decision that it kind of set the table for that, where the judiciary is able to look at cases on a case-by-case basis and make those decisions. I worry sometimes we look at everything as a legislative fix, and there ends up being kind of this meat cleaver approach rather than the scalpel that the judiciary can take to it. You mentioned states that have done this from a legislative standpoint. Are there states that are dealing with it from a judicial standpoint, as Kentucky is now?
That I would have to look into. I can see if I can find the answer to that. I'm not sure off the top of my head.
Okay, and on to the issue of accountability. You know, our juvenile code currently intentionally severely limits some of the consequences on juvenile delinquency. With the exception of youthful offenders, the idea is supposed to be meaningful intervention and getting treatment and things like that. So do you believe that this could lead to, as the senator was mentioning, a lack of situations where youth would get the interventions they need?
I don't think so. And again, what we are advocating for is just to make sure that kids understand what their actual legal rights are. It's not anything really beyond that.
Sure. You also mentioned that some states are requiring consultation with parents or are allowing parents to waive rights for youth. And I'll have to turn to Mr. Preston to correct me if I'm wrong. My experience is when we're in court, the Department of Public Advocacy is very quick to say when there is a parent that wants to make a legal decision for a child, they say, no, we're not listening to the parent. We're consulting with that child. That child is our client. So if we were to do that in Kentucky, that would be kind of turning that on its head and then having the parent able to intervene and waive rights for children. So is that, have you thought about any consequences of that kind of somewhat of a sea change as far as the way the Department of Public Advocacy approaches that?
I have no, and I'm not a lawyer, so I have not thought about it in that context, but I do appreciate you bringing that up, and I think it is good for us to think about too.
Thank you. Thank you, Mr. Chairman.
Thank you. Mr. Preston.
Thank you, Mr. Chairman. So I look forward to hearing the rest of the presentation, so we hate to put the whole burden on you because we have other lawyers that are going to be talking. But a request that I would have is the Maryland, the Indiana, and the North Carolina laws, could you submit those to the council so that we can see the language of those? Because it's clearly some of the questions that we've got probably would be answered to look at the actual statute.
I actually have information on I think every state that has anything related to custodial interrogation, and there are links in there too, so I can just share that entire document with you.
Yeah, because all of these questions, they're good questions, but I'm sure we're not the first people to be asking them. So,
I get it.
So it would be good to know how they've been resolved. I do think, just to respond to some of the senator's good questions that he had, I think there's a big difference between parent and an attorney. I've certainly had cases when I was in court. I did a lot of juvenile court, and the parent's view I think juvenile court, even more than adult court, a parent often comes in and says, Johnny, just tell him what happened. Johnny, just tell him what happened. And you know, if I'm standing there, you know, just to back up some of what the senator said, I'm going to say, Johnny, maybe don't tell him what happened right now. Let's have a conversation before you tell him what happened. And so I do think, I think parents should be involved. And if there is a legislative way to make sure that they're involved, that this child has support from their family, if it exists, that they can be present, I think that's good. But I do think an attorney is important. And as I understand your recommendation, as you have it on the slide, it's simply to require kids to speak before they waive their Miranda rights.
Yes.
So it only is when Miranda is implicated, which is a custodial interrogation of somebody that is potentially going to give incriminating statements.
Right.
So this isn't if law enforcement shows up at a domestic violence incident and there's a kid there who saw it,
Yes.
and they're speaking to the child as a witness,
Right,
or
yes.
as a let's figure out if there's an emergency here. We're not talking about that kind of situation. We're talking about a child who's already been taken into custody,
Yes.
presumably on at least probable cause, if not higher.
Yes.
So we already have legal structure in place here, and every one of those kids, if this is a Miranda situation, already has a right to counsel.
Right.
So they could all be saying yes today, and then we're at exactly the same place.
Right. That's
But
true.
some of them are saying no, and this would require them to talk to an attorney before they say no.
Yes. It's very
Okay.
helpful distinction. Thank you.
I think that's it for my questions and comments right now. I appreciate your presentation.
Thank you.
Thank you, Co-Chair Storm.
I think I'm going to defer my question until after I hear from the prosecutors, just because I want to get their 2 cents on the issue before I ask a question. She may answer it, or they may answer it.
So we'll have our prosecutors come forward, if you would. Okay. And I don't know if you had any remarks that you want to make, or if you just were prepared to answer questions, or what you'd been told today.
As far as I'm concerned, format is up to the council.
Okay. Well, why don't you give us some observations as to what's happening in your counties with juvenile cases, and whether or not this is an issue with custodial interrogation of juveniles where they've invoked their Miranda rights, and maybe you've had a case where you thought the confession wasn't necessarily accurate or true. I don't know if any of you have had that in your counties, but I think that's the concern here. Obviously, is that a juvenile would be forced into, based upon the interrogation, of making a false confession, and their constitutional rights not preserved. So if you turn your, okay, I'm being told what to do here. If you will turn on your microphones and introduce yourselves, then you can proceed.
Hello, I'm Jason Darner. I'm the Marshall County Attorney.
I'm Jenny Heyman. I'm the Madison County Attorney.
So I was asked to come speak today, I think primarily because of my prior involvement with the school shooting in Marshall County, January 23rd, 2018. Obviously, the day that we will never forget there. And respectfully, when I was listening to the presentation before, a couple of things that I did take issue with, again, respectfully. And that seems to be that the position was that the juveniles are all in the same boat, that they all have the same deficiencies in terms of intellectual ability to make decisions for themselves. When I think that if you spent any time in juvenile court, that juveniles are not a lot unlike adults. You have some juveniles who are much more sophisticated than others, just like you have some adults who are much more sophisticated than others. And although as a former juvenile, I will concede that when I was 15 and 16, did I make bad decisions, and did I rush to judgment? Sure. But was I incapable of understanding the situation that I may have brought myself into? No. I mean, I understood full well growing up watching TV and listening to the Miranda rights on Miami Vice and all the other TV shows, Hill Street Blues, I'm showing my age, that you do have a right to remain silent, you do have a right to counsel. So I do think it's painting with a little bit of a broad brush to say that every juvenile needs to talk to an attorney before they're capable of waiving their Miranda rights. And so that is an issue that I would take up. And also, our existing system, and I don't want to steal Jeannie's thunder, so I'm gonna shut up here in just a second. But our existing procedure, if a child is taken into custody, it's 610.201. It's the parental nullification statute. And so if a child is taken in, there are already certain rights that immediately attach to that child in terms of telling the parent, okay, your child's been taken in, here's the nature of the charges, and things of that nature. And the parental notification, I think, is really what we have already in place that addresses a lot of these issues that former presenters brought up. So I think we do already have a kind of a good plan in place. And that parental notification is such that if there is a technical violation, the way that our case law is, if there's a technical violation and maybe the parents were not notified immediately, that's one factor that can go into a judicial finding that a statement made by a defendant or a confession was involuntary. So I do really favor our case-by-case basis where the totality of the circumstances dictate whether or not a statement made in custody is voluntary or not. And that's really, I think, our position at this point.
So, in addition to being Jason's moral support, the reason I was asked to come here is I'm going to just confess my age and tell you now I've been prosecuting for just shy of 20 years. The first 13 and a half of which I spent a majority of my time handling all of the juvenile and family court cases in the jurisdiction in which I prosecuted. And so it's kind of an area that's near and dear to my heart. It's hard to see kids grow up, and I still see them now in adult court or vice versa, and their next generation. But it's one of the areas where you get a lot of satisfaction out of seeing growth and success as well. We do not have a huge problem with, in Madison County, necessarily false confessions and statements. What we do see is a huge problem is the change in the criminal nature of our juvenile offenders. When I started prosecuting, it wasn't uncommon that a majority of my docket would be 16 or 17-year-old, and I'll pick boys that may get in fights, or something like that, and I'm jerking them into court saying, we can't act like fools sitting on the corner of the festival and things like that. Now it is not uncommon for me on an almost a weekly basis to have school terroristic threatening charges processed, to have actual hits on students. We have some that these juveniles, they're using cryptocurrency to purchase the guns, to hire the hitmen to come to school, and it is beyond what I ever imagined 20 years ago of what we would see in juvenile court. And it's just a different generation. I do agree, our position with Jason, we already have these protections in place as a whole. It's really hard, and you guys do it on a regular, so I give you all the respect. It's hard to legislate with a broad brush to factor in every circumstance and situation. But I do find it difficult to treat them the same if you're going to legislate for those who may be charged with a criminal mischief or a shoplifting or theft charge, the same as I'm dealing with my terroristic threatening kids, where I'm trying to immediately intervene with the school, not let them back at that school and handle it that way. Our case law set up, like Jason had said, with the totality of the circumstances. And that's just not a vague clause that we use. There are elements that we look at. We look at their age, their education, their experience with law enforcement, their background maturity, and their mental and physical conditions. Additionally, the law states the officer doesn't go in there to a juvenile and have to give them the verbatim Miranda warnings that we're used to, right? They're able to talk to them and explain it to them in a way for their age or processing level to understand. I don't have to stay here. If you want me to leave, I have to leave. We've had this come up. I've had my officers come talk. We've done trainings. When you're dealing with juveniles, you speak with them on their level. You relate to them so they do understand. Their parents can invoke that right to counsel upon that notification. They have the right to do so, and then we'll go from there. But saying that law enforcement's explanation to a juvenile, as the law states they can break it down to speak on their level, versus an attorney's explanation to the juvenile is different, I have a hard time necessarily saying that's across the board the same. So, to answer, I guess, Chairman's question, we don't really have that issue in Madison County that we have seen or has come to rise to the level. But I do think trying to legislate with such a broad brush would be difficult in a lot of the situations where we've just seen generational changes of what our juvenile offenders look like.
And just brief follow-up on that, again, anecdotal, turning back to the school shooting case. The shooter in that case was 15 years old at the time, and he was reading Anne Ryan novels in his spare time. I mean, this was a pretty sharp kid. When they brought him into the interrogation room, the officer went through his rights with him. He said, "Those are my Miranda rights." He knew Miranda before Miranda was ever said to him. So this was a situation where we were dealing with a very, very sophisticated intellectual juvenile in that situation.
Well, thank you very much. Does anyone have any comment or question of the county attorneys? Mr. Preston.
Hey, I'm actually not going to ask you a question in your prosecutorial role, and so this may be better for Senator Carroll, but Ms. Heyman, since you talked about working with your law enforcement officers, do you all know, is there training, formal training broadly for law enforcement officers on how to conduct juvenile interrogations differently than adults? You said locally in Madison County, maybe you know about it, but are you aware? Is there anything beyond? And if you can't answer, that's fine. You're just, among the panelists, you're most likely to know this.
I know they have very broad training. I do not know that any of on their kind of association level or on the state level that they're receiving any specific training. I do not believe it's necessarily like part of DOCJT's curriculum. Having worked with them some, I don't think there's anything specific to juveniles. I can't speak, obviously, for 119 other counties. We just have a really good relationship with our law enforcement, understanding that I may often tell them they were wrong, but I'm also there to try to help them accomplish this in the best way possible in those situations. So we do a lot of that interaction amongst us locally.
I do believe, Mr. Preston, that there is some specific training for the SROs, the school resource officers. To what depth or degree that training goes into, I'll claim ignorance on that one. I just don't know.
Thanks.
Any other member seeking recognition? Co-Chair Storm.
Thank you. First and foremost, thank you for being here. And Ms. Hammond, you mentioned that over the course of your career, the nature of the crimes that you've prosecuted have changed. So you kind of gave an example. So do you see this kind of as a scale of there are certain offenses that might not result in a juvenile being detained, but then there's certain other offenses that are more than likely going to require a juvenile to be detained?
So I think, even as with adults, right, as we've prosecuted over the generations and seen, there's kind of a flow of what used to be or maybe considered very severe and serious 20 years ago. We've now had to take, not that it's not serious now, but the severity in comparison to what we do see is very different. And I think we have to look at that on a local level. You guys are going to be very upset if I still detained everybody that was detained necessarily at the beginning of my career. For those detained now, where these juvenile facilities are going to be held, right? We're going to have that same problem of what we see a lot of times with adults. And so I do think there's a lot more discretion in that, and that's part of that local discretion is knowing and working with your local agencies of, hey, this isn't something that necessarily this kid needs to be held for and detained. And so I think that affects the long run of it. But it's just that we see so much more of the severe cases. I mean, we all know it. We all see it. The school shootings that we come across. I mean, we can't be in a conference when one of our colleagues doesn't have to leave because they've had a shooting at a football game or something like that. Those are the situations where I feel like it's really hard, notice what Senator Carroll said, to just stop and say, nope, we got to get an attorney out here. When you're having someone who's shooting up a school, we can't, and there may be a bomb somewhere or something, we can't stop everything. It is about now dealing with that emergent situation and how do we find out the most information we can to protect everybody else involved. I don't ever want to violate the rights of the one individual. As a prosecutor, my goal is that adult, child, anybody gets a fair trial and their fair day in court. But we also have to look at what we're facing in that immediate time and how we protect everybody else in our communities.
May I have another question?
Yes, please.
So does it appear to be that you've talked about felony type conduct where the school shooting type situation, and then you talked about other situations where that would normally be going through the court designated worker, but you all have local control to say, hey, I don't want this student in a diversion, I want to prosecute them through the court system. So in my mind, I'm compartmentalizing these. Maybe that's not the right thing to do. I'm thinking felonious conduct and then other conduct that might not be felonious. And so you see where I'm going with that? Okay. And so maybe that's something to think about. I guess my question is, any sort of interrogations of these students or these children, are these being audio recorded and video recorded as a standard, or is that just department by department, or is that county attorney by county attorney, or do you know?
So any of our interrogations by, I will say, all but one of my agencies have body cam. So whether it's an adult or juvenile, those body cams are engaged. We have one local agency that doesn't. So I would presume that it's the general rule across the state that if it's an agency that has body cam, that body cam's on during that interrogation.
Same situation in Marshall. We have a sheriff's department, 2 police departments, and obviously Kentucky State Police, and all those agencies are equipped with body cam.
Thank you, Senator Carroll.
Yeah, but that's not mandatory. We have not made that mandatory. It wouldn't always apply. And I guess I've been out 15 years now, maybe, and I don't remember the obligation to call a parent back when I was an investigator, that we were able to address, Mirandize, interview the kids without parents' notification at some point. And I don't know when that changed. Jason, do you know when?
610.200. I do not know. It's been on the books for a while because
maybe I'm just older and my memory's going away. I don't know. It's possible.
Well, there was the primary case that we cited in our briefs when we were litigating the school shooting case was Taylor v. Commonwealth. And there's also cited within that case is Murphy v. Commonwealth, and those 2 cases both discuss that parental notification statute. And I would just note for the record that Murphy was decided in 2001, so it's 25 years old, I would say at least.
Okay, and I understand about the custody, and that was something always standard, and juveniles were always treated the same, and I'm sure they still are when it comes to custody. However, juveniles, sometimes it's a different approach with the way you're dealing with what they're doing. And, even with fights, if you get out, you can't, under this mandatory notification of attorney, the lines would get blurred very easily. 2 kids are fighting, so you can't just go up and say, hey, what happened? If one of them's got a bloody nose, could have a broken nose, could be charged, you can't just walk up and say what happened under that. You're going to have to call an attorney and get an attorney there before you do that. If you're detaining them to investigate what has happened, otherwise you just let them go, say, have a good day, guys. So I can see some issues with that, and I absolutely understand protecting the rights of kids, and I don't think any of us want to not do that. But they're kids, and it's different from adults, and there has to be a proper balance there. And again, I say this from experience, and I know the world has changed in 15 years, and the kids are completely different from what I dealt with then, and it's a lot harsher, a lot more dangerous, doing things like you said that we never encountered during my career, but that's common these days. So, different world. Thank you, Mr. Chairman.
Thank you, Senator. Any other member with any comments or? Yes, Ms. Walker.
I think you address or spoke of the child, the juvenile, who knew about his Miranda rights. And I am an educator, and I've been a special education teacher for 16 years. And what do we do, or how do we explain to these children who have a cognitive delays or deficiencies, and they'll tell you they understand, but they really do not understand? You all won't have that information. They have an IEP with the school district, but when you all are interrogating, you won't have that information to make sure that they do understand their Miranda rights. So how do you handle, or how would you handle an issue like that?
Very good question. I think where I would fall on that is the information that you may have as an educator with the IEP, with the cognitive disability, the history of this particular child. I think that's probably fair game to introduce at a hearing to determine whether or not the statements made by this defendant child were voluntary or not. I think that's certainly a relevant factor that any judge would want to know. Okay, was this child in AP English Or is he or she, what kind of books were they reading? Are they IEP? You know, what are their test scores? I think that's all fair game, and that, again, that comes back to one factor among many in the totality of the circumstances test that we have.
And I would add to that, ma'am, that's some of the case laws already address that on point, that those are the factors the courts look at. And so there's law on there that does come into play, and that may be a cognitive deficiency, that those are going to factor into whether or not that was a voluntary waiver or a voluntary statement made, and if it gets suppressed or not.
Thank you. Any other member with a question or comment? Co-Chair Storm.
I guess also going on with what one of the prior speakers mentioned, or person that had a question, you know, we're talking about situations where these individuals may have parents. And we talked about this statute in the event they can locate a parent, but oftentimes we see situations where there is no parent, there's no guardian ad litem yet. It's going to require a family court judge in my jurisdiction to appoint a guardian ad litem. And so we recognize there's also those situations, those individuals that don't have a parent. And then the statute talks about they can still be held for, I think, up to 2 hours while the officer continues to conduct the investigation, even though they haven't notified a parent or been able to reach a parent. And what happens in the scenario where they cannot reach a parent or a custodian? What happens then? Do you know under the statute?
If they cannot reach them, as far as notifying of their Miranda, I think based on some of the case law and depending on the circumstances that the interrogation can proceed, they've made the attempt to make the notification. For those, you know, in those situations that you and I are all too familiar with that maybe not have parents, if they're in cabinet custody or state custody like that, they step in. We do have to notify DJJ or the cabinet if that's who the guardian is prior to that situation. But in situations where we can't just get a hold of them, that they have them and we can't get a hold of them, the law allows for that interrogation to proceed. But again, then it gets to court, all those circumstances come into play of what happens during those statements, and if they made a voluntary waiver and a voluntary statement, how that is affected.
So in these states that have adopted some form of what we were presented earlier by Kentucky Youth Advocates, and I'm reading here that Delaware, Illinois, Oregon, and Utah have adopted laws that say law enforcement cannot use deceptive tactics when interrogating. Colorado, Indiana, and Nevada have enacted laws making a young person's statement inadmissible if deceptive tactics are used during questioning. Do you think that's made it more difficult to prosecute these cases in these states where they have laws like this, or have you had the opportunity to talk to prosecutors in these states where they've added these additional protections, and what would your opinion be as to whether or not it's more difficult, I guess, to secure a conviction in those places where these laws have been enacted?
I have not. I would again, not to beat a dead horse over the subject, but going back to the standard that we have, the totality of the circumstances, I would certainly think that if I was under investigation and being interrogated, I think the officer would have feel as though he had a lot more freedom to beat up on me as opposed to a 12 or 13-year-old child. And I think a reviewing judge would be a lot less sympathetic for me falling for a deceptive trick as opposed to a 12 or 13-year-old child.
Senator Carroll, recognize.
Yeah, and I think that's a great answer, and I think that's very applicable to these circumstances. But in any investigation, an investigator comes into the situation at a complete disadvantage, and the ability to try to convince a suspect that you know something that you don't is critical to the success of investigations often. And does it go too far sometimes? Absolutely. And normally, you know, I remember in talking with other investigators, you do with juveniles, you temper that to a level. You don't go to the extremes that you might with an adult, but that's basic investigative technique, and we are under no requirement to tell the truth on things, and you have to convince a suspect that things that you don't to sometimes get a confession on it, but the court always has that ability to look at that confession and how much pressure an investigator put on that child, and make that decision within court. So I would never support a law that would require law enforcement just to be 100% truthful all the time. And I know that may sound awful to a lot of people, but guess what? Criminals aren't just going to confess if you ask them if they did it. And sometimes it's just a good interview technique that solves a crime and leads to justice. And that's why we have the court system, is to determine how far is too far and all those types of things. So I would struggle with changing those laws to affect investigative technique. There should be limits, yes, and the courts determine what those limits are.
Thank you, Senator. Any other? Mr. Gold.
Thank you, Mr. Chairman. As often, Senator Carroll says things better than I was going to say them, but I do want to get back to this whole key of this issue comes down to voluntariness, and that's what courts look at. Courts have to decide on that case-by-case basis, was this voluntary given this particular situation and this particular child? And that, I think, I really worry about legislation taking the place of judges looking at that individualized case. I also want to point out what I'm seeing in juvenile court is often parents or guardians are the victims. Just the other day, we had a 15-year-old that's about 6'3", huge, and he was hitting about a 5'0" grandma, and she was the custodian. So I think if we legislated something about that and about whether or not she could waive his Miranda rights or under Galt, that I think is actually a problem and can be an unfairness thing on the for that juvenile. I also have major concerns about our SROs, and if they have to every time there's some sort of scuffle between a couple of people pushing each other around. This idea of having to stop everything just to find out what happened is a problem, but even more so, my biggest problem, and I think Jenny touched on it earlier, is we have a problem. What I've seen in my years prosecuting is a very huge increase in a problem with kids with guns. Kids with guns is becoming a big problem not just in Henderson County, but all across the state. And in those investigations, time is of the essence very often, not just to investigate that particular shooting, that particular crime, that time that young person brandished the weapon at school or whatever it may be, but also to find that weapon, secure it, find who supplied them with that weapon, because we have in so many communities, too many communities in Kentucky, adults that are willing to supply juveniles with guns. So finding that out, honestly, to me, it's much more important to figure out how these kids are getting those guns and go after those adults that are making that happen. And frankly, any speed bump that occurs in making that happen, I think makes all of us less safe. And again, I think we absolutely have to look out for the rights of the individual, particularly the individual juvenile. But we have to remember that in so many of these, time is of the essence.
And I just to go back to not to play devil's advocate, which I've been accused of doing over the course of my life a few times, but to go back to Youth Advocates' presentation, they did suggest that we carve out when there's an imminent threat against a person or property. So I think that's goes to your comments. I don't think they were suggesting that the situation that you have discussed would be where this would apply. So, Mr. Preston.
Just a couple of comments, and we have a couple of our lawyers that are on the agenda that'll be able to make points better than I do. But just in response to Mr. Gold's comment and some others, you know, Miranda was decided in what, 69? We have over 50 years of law and case law development in when is it required, and all of these questions are answered as far as when there's an exigency, and remember that we're not talking about arresting a police officer for questioning a juvenile without a lawyer. We're talking about the admissibility at an eventual hearing, and so the worst case scenario is that something's deemed not admissible later on. A couple points that I would make. Number one, it hasn't come up. Everybody knows it, but I'll just bring it to light. The law recognizes all kinds of decisions that 17-year-olds can't make legally. This is not out of line to say that someone who is 17 or under cannot make a legally binding decision on their legal rights. There's plenty of that already written into the law. 18 is a meaningful year legally. This would be consistent with other laws that we've got that recognize that juveniles should not be giving away their rights easily. And then there's a tension here, and this is kind of, as we talk about this more, if there's specific legislation proposed, there's a tension here that I'm not sure how it cuts. I know how I think it cuts, and others would disagree with me, but the examples for when this would get in the way, in my mind, are the exact examples of when it should get in the way. If we're talking about school shooters, if we're talking about possessions of guns, if we're talking about serious crimes for which a 15-year-old could go to prison, that's exactly when a lawyer should be involved. And so if it's the school fight, the two guys fighting and police are just trying to figure out, sure, don't have this not apply to that case. But the ones that are the examples that have been given in this hearing to say this is when we shouldn't do it, my response is exactly the opposite. That's exactly when we need it, because we shouldn't have 15-year-olds facing adult punishment when their 15-year-old brain is not understanding in the most stressful moment of their life, what rights am I giving away if I sign this paper? So I think this is a very limited recommendation, but I think it's an important one.
Thank you, Mr. Preston. Any other? I know we have another presenter or two other presenters. Any other comments or questions or any from the panel, any response that you'd like to make? Okay. Thank you so much for your time.
Thanks to the council for having us.
Thank you. Thank you for coming today. So if Laura Karam and Lindsay Yates would come forward, Department of Public Advocacy, and introduce yourselves and turn on your microphones, and then we can proceed, and I'll allow you to have some opening comments, and then we can do much like the last panel, if that's okay with you.
Thank you. Okay. Can you hear me? I know I'm not real loud.
Yes, we can hear you.
Okay. I'm Laura Karam. I'm the Juvenile Post-Disposition Branch Supervisor for DPA. I've been with DPA for about 19 years. I'm also on the Juvenile Justice Advisory Board as the DPA representative.
Hi, my name is Lindsay Yates. I am a juvenile specialist with DPA. I've been with DPA for 4 years, and in that time I've been a frontline defender in Fayette County, where I only represent murder cases and juvenile law. And I'm now the directing attorney of the Harrison County DPA's office.
So just give us some observations as you've watched our hearing this afternoon, and if you would, and some of your experience in these types of cases. Okay, thank you.
Okay. I brought some notes which overlapped a lot of what KY presented as far as the national sort of state of the union with these types of bills. There was an ABA resolution in 2024 around custodial interrogation and recommending that youth are protected.
ABA is the American Bar Association.
Recommending protection for youth before they're participating in custodial interrogations. Of course, the American Bar Association thinks attorneys are important at that stage. There's also a recent article from the National Center for State Legislatures that talks about the recent laws that strengthen the rights of juveniles during interrogations, and much of that information overlaps with KYA's presentation, so I won't repeat that. And then in preparing for today, I looked at an International Association of Police Chiefs article on reducing the risks and effectively interviewing juveniles, where they also are not necessarily asking for attorneys at every interview with law enforcement. But that article recognizes the brain science and susceptibility of juveniles and the information that you've discussed regarding false confession and that risk in this age group. So we have sort of the state of the law, the constitutional right to remain silent and to have an attorney generally in the JDB versus North Carolina case that came out in 2011 that looks at age as one of the factors in whether these sorts of interrogations are giving voluntary information. Kentucky adopted that in NC versus Commonwealth a few years later. I think it's really important to point out that when we are in formal court, KRS 610.0602B doesn't allow a child to waive counsel until they first consulted with counsel. Kids don't understand the rights they are waiving until they talk to an attorney about what those rights are. So even when the court's deciding whether or not you get a public defender or DPA attorney, they're supposed to allow you to consult with an attorney first. That covers a multitude of issues that have come up and been litigated over the years, and that's why that statute sort of exists. There was case law before that. Things you've mentioned already, that the parents may be the victim, that the child may not have a guardian that's present in the sense of like right there by their side. They may have a foster parent or social worker, maybe in a congregate care setting. That child may be in detention, has charges arising from the detention center even. So it's helpful to be able to consult with an attorney when they're deciding if they're going to have one in court, which makes sense that they would need that same protection if they're facing custodial interrogation. So obviously I'm not going to disagree with any legislation that's going to appoint attorneys to kids before they're interviewed by the police. We have, not with us today, but the Kentucky Innocence Project has had Janetta Carr speak before the legislative body in the past, and she was 16 when she falsely confessed and went through exoneration, and I think recently resolved a civil case. And so we know that this has happened in Kentucky. We also know that that process took something like 10 years, and that's about the average sentence that KIPP will even bother looking at. So we don't have a ton of data on how many assault fourths that kids are falsely confessing to. We just know that when it happens, years later, we have these sort of terrible situations where somebody who is innocent has been in prison for years, and then we're trying to fix it. And this, from the ABA, from the National Center for State Legislatures, even from the International Chief of Police Association, this seems like a good way to prevent that. There's various sort of case law around what counts as custody. You know, that can be litigated in court, but it is just about admissibility. I like to think about the times when I was a trial attorney in the Harlan office, and our clients would say, well, they didn't read me my rights. And like, they thought that was a big deal in the adult world. And most of the time, it's not a big deal in the adult world because they caught you with the drugs in your pocket. I have had a kid walk through blue paint after criminally vandalizing a home and leave blue footprints up to his porch, right? Like, you don't need a special investigation or interrogation to solve that crime because our kids are not as sophisticated broadly compared to our adults. So if you have questions about sort of the workability, I think that having an attorney available for consultation early on actually makes it a much clearer decision for a court. I had a call on the 5th about a kid in an outlying county. The parents were calling to see if they could have an attorney for an interview with police. We have some early entry things. There was consultation about that, but that's the kind of thing that actually improved the process in that specific instant, because by consulting DPA talks with the county attorney, they can set up an interview, they can make it all go smoothly. There was questions about adult conduct and trying to figure out how this young, intellectually disabled youth with an IEP could be involved in receiving stolen property. And the parents had some ideas about who the bad actor was, and they wanted to be able to talk to law enforcement and cooperate. It's been my experience with juvenile post-disposition that we get calls when law enforcement wants to come talk to kids in detention facilities, in EDJJ facility. And a lot of times that's not an interrogation about a case that they're involved in as a suspect. A lot of times it's because they're a witness. But sometimes they are a suspect, and sometimes we advise them not to say anything and, arrive on scene, and the law enforcement officer may want to check, make sure that they're still exercising their Fifth Amendment right, and that kid might change their mind in that moment. But having the consultation with the attorney means that they are going into it knowing what the consequences of their statements might be.
I would just encourage the members to not think of adding a step as a hindrance, but rather as a safety net that would prevent further judicial time being wasted. If we are presenting our children with options and education at the very beginning of an investigation, what we're going to do is, instead of wasting our time trying to figure out what's important, is this an issue, having hearings, we are actually getting to the point of why we're here, and that is the seeking of justice. And kids are children. Like, we treat them differently. As Mr. Preston said, we have whole chapters in the statute books about how this is a protected class. You think of it like a 17-year-old and an 18-year-old is not that different. And the realistic truth is that it's not. But legally, that is the number that we have chosen to create as an adult. So I would just encourage that we look at it as something that could prevent us from not only wrongfully accusing and wrongfully convicting children, but also to go to the point of why we're in juvenile court, which is to provide services, to give rehabilitation, and to prevent from recidivism in the future. Children who I often come across are already at a disadvantage in life. And I believe that it's not always as obvious to the layperson as it is to somebody who's in my shoes, who has been trained in what to look for intellectual disabilities, abuse, just all the stuff that I see daily. You don't see that. And no disrespect to the police, they don't either. They're there for a job, and I am there for a job. But the police are there to solve an investigation, and that is their goal. They are not thinking often, how is this going to affect this child's future? They want to solve a crime, and that is their prerogative. That is why we have the police force. However, we can't do that at the cost of our youth, and that is what's often happening now. As Ms. Walker said, oftentimes children may mask well. That is the term that we use. They mask well because either they're not engaged in school, or they're not, they're able just to show, pretend like they're doing okay. They're not. And when you have somebody who's trained to recognize that, such as me or Ms. Karam, you're able to recognize that and then advise them more clearly and more appropriately, instead of, just being like, okay, these are your rights, let me read this to you. And that also brings me to a very sad, and I dare to speak about it, but I'm going to. Police are not treating children as children. That is a criminal to them. That is somebody who is actively a threat to the community. And oftentimes that's not necessarily true. Yes, children do crimes. They do bad things, but they are still a child. And children don't do crimes for the fun of doing crimes. We have gotten here after a long road of trauma, abuse, neglect, hunger. And I don't think that's always recognized in the moment when a police officer is trying to figure out what happened to another victim. But oftentimes a child is also a victim. And I think adding another layer of protection would not only add to the protective, constitutional protection of a child, but also would get to the true issues of what is happening in an investigation. I'd also like to talk about the word voluntary and how we talk about, is this voluntary statement? And I've had a lot of experience where, the judge says, oh, well, they voluntarily waive their rights. I encourage us to look back onto when we were 12, 13, 14, 15, and what we thought was expected of us. You know, when I was a kid, I was taught that, you know, adults are the superior beings. That is who you defer to. That is who you're supposed to respect. And even for children that don't have, you know, somebody, like parents as great as mine who taught me these rules and how to behave, you still look to authority figures for guidance. And that is just innate in our society. So when you have a young person who is surrounded by, you know, their parents, the police, teachers, their SROs, even just the CDW, those are authority figures to them. And they cannot always separate what is my right here versus what am I expected to do. And when a child is expected to behave a certain way, the majority of the time, that is how they're going to behave. Even if, you know, that's not what they want, that's what they're going to do. So if we are able to give them a safe person, a safe adult, a safe authority figure to be there on their behalf, I think that would go a long way in not only, you know, protecting their constitutional rights, but also in possibly helping with an investigation as well. I don't think it's as much as a negative to one side or the other as we might think it is. I think that we could actually use an advocate and a counselor as somebody who can work with people instead of just saying, oh, no, don't talk to the police. Most of the time, that's what I'm going to tell my kids. Like, no, we don't want to talk to the police. But sometimes it gives us a heads up into like, okay, maybe this is what we should be looking into. And then maybe we can actually get somewhere with an investigation and a case. I believe that about does what I would like to testify to, but I welcome any questions or comments.
Thank you very much. Does any member have any comment or question of the panel? Co-Chair Storm does. Please proceed.
Can you tell me, is there a capacity at DPA in order to even comply with the 24-hour legal hotline? Is that even feasible?
I believe so. You know, there are a set of juvenile specialists that do special training, but I'm a part of that training, so I know how many people are available. And we do sections of the state, and I do believe that if it was a hotline or even like a FaceTime kind of setup, that is something that we could absolutely do. And I also think that juvenile specialists have a special interest, and that if it's possible, like they would even come down to stations if it was given that opportunity in that more case-to-case basis, which I think is something that would have to be addressed. But even if it's not, if they're just being custodially interrogated, I think that a hotline would be appropriate, and that we have the resources.
Can I add to that?
Then I just have
And
one
I think Ms.
observation.
Karam has something.
Please proceed.
I was just going to add, compared to other states, we are uniquely positioned with a statewide defender agency and offices in like 33 counties.
Yes.
So we have the geographic reach to be available. And then also as somebody who's responded to those calls for law enforcement, needs to interview this child, can you be here? The answer for me is usually yes, I can be there. Let's just figure out the time that works for you.
We make it work.
Yeah, we make it work. But, you know, we've looked at sort of what would it cost to put in an 800 number. You know, we've got contract attorneys, so we already have the conflict division and contractors available. There's different ways different states have handled it, but I think DPA can handle it. We, of course, would always like additional funding.
Yes, please. And
I was going to say, they are not waiving the right to ask for more money.
And Senator Storm, just briefly, I know that oftentimes I'm contacted by DJJ or the cabinet as a preemptive, like, hey, we have this kid, we think that they're going to be interrogated. Would you be available? Like, just a heads up. And that's something that I think with this system would be able to do instead of just with when parents are, you know, in charge of their children instead of the cabinet.
Okay. And then just a couple observations. So if I'm not mistaken, KRS 402.020 in Kentucky says that individuals under the age of 18 can't even enter into a marriage, if I'm not mistaken.
Yes, sir.
Unless they're pregnant in certain circumstances, if I'm not mistaken, but only while that child is still in the womb. And so it's a very limited circumstance when individuals under 18 can even get married in Kentucky. And then also KRS 510.020 defines a lack of consent to engage in certain adult activities, one of which is sexual intercourse, is at 16 years old. So individuals in Kentucky can't even consent to that under the age of 16. And the last thing I would just note is, you know, I do practice in this area somewhat, and going back to Senator Carroll's comment, oftentimes after I interview my client, I do, and I think that the county attorneys would possibly verify this. Some attorneys actually tell their clients, you know what, go in here and give a statement, give an interview,
Mm-hmm.
because it may have exculpatory information that helps your case. So not every time that my clients contact me do I ask them to remain silent or instruct them to remain silent. Sometimes I say, you know what, go tell the truth.
Yeah.
Go tell the police what happened. Because more often than not, if you're going to be in the court system, that might help your situation more than remaining silent. So it's a fine line. Thank you for your testimony.
Thank you. And if I might, this is my first time testifying, but I was wondering if I could respond to something Mr. Gold said earlier.
Please, yes.
Yes, Fayette County.
He may want to respond to.
Oh, sorry.
But that's fine. You may want to go ahead.
Mr. Gold, as I said, I practiced in Fayette County, and guns have become a serious issue. And what you mentioned is that oftentimes we need to figure out where these guns are coming from. And I can guarantee you the answer is going to be, I found it under a bush. I wish I was joking. It's always the same, hundreds of cases. But I do believe that if we were in a position to advocate and be there with the child when they're first being arrested, or if, a gun is found, we might be able to actually get somewhere where we could stop this influx of weapons being brought into children and given to children, because that's exactly what is happening. Adults are giving these kids guns. And if we were able to give them a trusted adult to talk to and explain that, like, hey, this is juvenile court, is this going to be, confidential, maybe we could also get somewhere earlier on in the investigation, instead of at disposition when my judge asks, like, so where'd you get the gun? And they're going to say, under the bush. So.
You're absolutely correct that gun bushes seem to have become Kentucky's native plant.
They have.
Du jour.
Senator Carroll.
Thank you, Mr. Chairman. And please, and I hadn't really thought this question through, but I'm going to throw it out anyways. We talked about with law enforcement the difference between law enforcement dealing with a kid and dealing with an adult, and on a defense attorney, public defender side, with an adult, your obligation is to do your best to get that person off. What is your obligation with a kid?
My obligation is to my child's goals. So if the kid says, I did not do this, I want to not guilty, then that becomes my goal. If my kid says, like, I think of, for example, like a sex case where, the children have had some sort of sexual interaction between siblings, sometimes they often tell me, like, I need to get out of this house. And that becomes my goal. So much like with adults, my goal is whatever my child asks me. However, I am in a unique position in juvenile court to say, hey, by admitting this or, talking with somebody about that, we can actually get you services that you would not have otherwise.
And that's, kind of what I was getting at is the philosophy different where it's more about what's best for that child, and sometimes what's best for that child is accountability for what he or she did rather than getting off on a technicality or whatever the case might be, that where should the emphasis be on that? And that's probably not uniform with all defense attorneys. Their goal is to use whatever, doesn't matter if it's a kid, use whatever procedural method they can to get the kid off. And is that what's best for that kid? Probably not. But I was just curious, never really thought about it that way, and it's just, it should always be a different philosophy for juveniles in hopes that we can prevent them from becoming adult criminals.
Yes, sir. The majority of the people involved with the child's life work in their best interest. However, I am a direct interest attorney. So, as is Ms. Karen, whatever the child says is their goal is what I work towards. However, with children...
And keep in mind, we've already said that this is a child that doesn't have the capacity to make those decisions, and that's why they need an attorney.
Yes, sir.
And you're doing that based on what a kid says that doesn't have the capacity to make that decision. Little contradiction there.
Correct. To which I would respond is that we are trained to work with children and to be able to counsel them, knowing where they're at and in their development and what their options are. And I believe Ms. Karam has a response as well.
This is the type of question we get all the time, right? So there's both legal ethics about working with clients with diminished capacity that apply to children. And then I think at the KBA conference this past summer, there was a presentation from civil folks, not me, about matching expressed interest with best interests. Ultimately, that is our goal, is to have what the child's expressed through advocacy and counseling match up with their best interests. We don't always get there. We're bound to express interest at the end of the day because we're representing that kid in a criminal proceeding. But like everyone, our goal is to have healthy, happy children who become productive adults. We're just in a piece of this system where we're advocating zealously for them to avoid the worst consequences out of court. So.
And the other actors in juvenile court are best interest actors. So working in tandem with them usually comes to a pretty happy medium of best interest versus express interest.
Mr. Chairman, thank you. I love these discussions, and I appreciate it very much.
Well, I do too, so that's something we agree
Me three.
on. Is this a widespread problem in Kentucky, false confessions in a custodial interrogation by juveniles, in your opinion? Is it a widespread problem or not?
Yes. I think we don't have great data.
Yes.
I think that it's difficult to answer when we don't have great data.
Yeah, we can't get official ansers. I just would have to give my own experience.
Yeah. I certainly can think of anecdotes.
Sure.
The 12-year-old who pled to a rape first at detention hearing, and then after investigating, it couldn't possibly have happened. But 12-year-old thought he was going to get out of jail. So, yes, whatever you say, let me out. We know those things happen. But also because juvenile court is treatment-oriented, a lot of times kids get some treatment or counseling, and it's sort of like, this is good for you anyway, and at the end of the day, you can get this expunged. So the mistake is not as damaging as some of the false confessions we see where clients are actually transferred to adult court and face adult consequences.
However, I will say with House Bill 5 being passed, the stakes have gotten a lot higher because now we're back to automatic transfer.
And detention.
How often, in your experience, and we all may need to do some research, honestly, to answer this question, but how often are statements of juveniles thrown out in Kentucky? And I know it's a very broad question, but in your experience, is that a typical
as an
decision
appellate
by court?
attorney, I think one of the frustrating things for me is that I don't get enough appeals. There are not, if your trial rate in adult court is something like 93% are not going to trial, well, in juvenile court, it's a higher number. Most of the cases in juvenile court are resolved by an admission of guilt to some level of charge and a treatment plan. I recently have an appeal where the judge threw out the child statement because the parent asserted the right to an attorney while she wasn't allowed to go talk to her son. I have a case where a parent had reported her child missing, and the police held him and interrogated him and sent him to detention and then told her what had happened. So she spent that whole 6-hour period not knowing if he'd been found or not. That statement honestly was irrelevant. There were witnesses to his conduct that came forward. He could have said anything, it wouldn't have mattered. But the case was remanded to juvenile court because there were some issues with transfer. So I will say we do see cases where the judge, under the totality of the circumstances, excludes a statement. And then we see a lot of cases that can flip it and say, I have an appeal from Bath County where, the client admitted to everything to a counselor while in treatment. That wasn't in custody. That wasn't law enforcement conduct. That was just making admissions in a non-criminal setting. And I have cases where kids have admitted to things right from the beginning. A lot of the sex offender cases actually are like that because the kids need help. It's almost like a scream for help.
Cry for help.
Please help. So I can't say that there is data on the number of suppression motions filed or suppression hearings held. That's something that we potentially could track internally, but we are not currently tracking internally. But anecdotally, both things, all the things happen from we have a confession we believe is not true and we see teams that are fighting that issue and looking for expertise, to we have a confession that's absolutely true and we're trying to get the best outcome for that child, to the judge has excluded the statement, but the hearing goes on with the other witnesses that are available. So I hope that helps.
It does. Thank you. Any other member seek Representative Wilner?
Thank you, Mr. Chairman. Thank you for your presentation, and thank you for inviting comments as well as questions. I just wanted to comment briefly. So I'm not an attorney, I'm a psychologist. And as a parent, as someone who taught human development for over 25 years, as someone who worked in non-clinical settings but with highly gifted middle and high school students, no matter how smart they are, and people will often confuse giftedness with maturity. It's not. It's not the same thing. And I really want to just thank you for your comments and for reminding us that these are kids that we're talking about. Their brains do work very, very differently.
Very different.
The research bears that out profoundly. Your experience bears it out. And I think it's so important, and so often in conversations about changing anything, whether it's in a legislative panel or whatever it is, immediately we start talking about the obstacles, the barriers. Oh, we can't do this. It would be too hard. And I really just loved what you said. We should look at this not as a hindrance, but as a safety net. And I hope as the Juvenile Justice Council here that we can remember those very wise words. So I really just wanted to thank you.
Thank you so much. I participate in a countrywide program for young public defenders, and I often say that Kentucky is the best place to be a juvenile because our system is very, very good. And, you know, I have so much pride in being a Kentucky public defender and juvenile specialist, and I hope that you all recognize that and also are happy to be on this board, and I hope that you take my comments to heart. You know, and just think about how we can, like Laura said, make these children as healthy and happy as possible.
Well, thank you very much, and I don't think any other member had any questions or comments, so we've had a really good discussion today, and I thank all the presenters for coming and talking about this issue. I think it's always helpful to have these discussions and get as much information as possible here. So I thank all of the members for their attention. And if there's nothing else to come before the council, we will stand adjourned.